Harvey Weinstein has consistently denied any non-consensual sex acts ever since the shocking allegations of sexual misconduct surfaced against him in October 2017. At worst, the disgraced mogul has admitted to using his position of power in Hollywood to elicit sexual favors. His attorney, Benjamin Brafman, has stated, "Mr. Weinstein did not invent the casting couch in Hollywood." On August 14th, in a first-of-its-kind decision, U.S. District Court Judge Robert Sweet ruled that Weinstein must face a federal claim of sex trafficking and a lawsuit brought by Katie and Noble. Noble accuses Weinstein of unwanted sexual conduct after promising the aspiring actress work. In response, Weinstein is asking Sweet for an immediate appeal over the issue of what qualifies as a commercial sex act under the Justice for Victims of Trafficking Act of 2015. Weinstein hopes he'll be given permission for the appeal to limit the potential fallout from Sweet's opinion. That prompted the producer's lawyers to express their expectation that some of the other women who are currently suing Weinstein may seek to add a sex trafficking claim based on Noble's success. Under the relevant trafficking statute, a commercial sex act must be shown. But what exactly does that mean, The Hollywood Reporter's Eric Gardner asks. If a commercial sex act is defined as something of value in exchange for sex, a quid pro quo, does the possibility of a film role represent value? In his decision, Sweet acknowledged that he was navigating uncharted waters on this issue and even paused a moment to consider Weinstein's hypothetical about an individual who treats a person to a free dinner, promises future gifts, and then attempts to engage in activity which he construes as consensual sexual activity. Would that be classified as sex trafficking? According to Sweet, notably absent from this hypothetical are the necessary elements of force, fraud, and commerce, all of which have been established here. Weinstein and his attorneys do not agree. There must be an economic component to a violation of the trafficking statute, writes the lawyers. To hold otherwise is to interpret the trafficking statute out of existence because it would be unconstitutional. Without a true economic component required, every alleged forcible sexual assault in which the victim complies with the assault in order to preserve her safety, for example, would give rise to a claim covered by the trafficking statute. As a result, Gardner poses another question. Will sex trafficking become a much bigger deal in courts moving forward, or will sex trafficking be confined to acts like forced prostitution and child pornography? Weinstein's lawyers told the judge this is a first impression case where there is a reasonable difference of opinion. They argue that it presents an important question that may result in a proliferation of cases. To read Eric Gardner's full article on Harvey Weinstein appealing the court to define a commercial sex act, head to THR.com. For The Hollywood Reporter News, I'm Lindsay Rodriguez.